Ladies and gentlemen, it's my great pleasure to welcome you to the Department of Justice and to this summit on modernizing the Administrative Procedure Act. My name is Daniel Fife, and I serve as Senior Counsel to the Deputy Attorney General. I'll be your MC today. We have a packed schedule this morning, so straight away let me introduce our first speaker, Claire McCusker-Murray. Claire serves as Principal Deputy Associate Attorney General and leads the Associate's Office in overseeing numerous DOJ components, including the Civil Division, Antitrust Division, and Environmental and Natural Resources Division. Claire previously served at the White House as Associate Counsel to President Trump, and before that, as a litigation and appellate partner at Kirkland & Ellis. Earlier in her career, Claire served as an honors program trial attorney in the Criminal Division Appellate Section, and as a law clerk to Supreme Court Justice Samuel Alito and then Judge Brett Kavanaugh. She is a graduate of Harvard College and Yale Law School. Please join me in welcoming Claire.
Thank you all for joining us to discuss the potential modernization of the Administrative Procedure Act. In the last several years, we've seen a remarkable resurgence of interest in the foundations and future of our laws governing administrative agencies, and for good reason. A significant portion of our law is now created through administrative processes. At this point, it is not an exaggeration to say that how a bill becomes a law can be less important than how a law is interpreted or enforced by an administrative agency. The question of how we are ruled, then, is in great part a question of administrative law. And there is no more important statute in administrative law than the APA, which for nearly a century has established the default rules governing the federal regulatory state. Surveying the landscape in 2019, there are at least a few reasons to think reform may be overdue. I will touch on just a couple. One, to which I've already alluded, is the exponential growth in the administrative state over the last century. Could the drafters of the APA have anticipated such a dramatic expansion in the size, number, and activities of administrative agencies? The APA's emphasis on formal rulemaking and formal adjudication, elaborate trial-like procedures that are virtually never used today, suggests a rather different vision. At the same time, courts have established administrative law doctrines that seem to give judges nearly unlimited discretion to block changes in policy. In Section 706 of the APA, for example, courts are instructed to invalidate agency actions that are arbitrary, capricious, or otherwise not in accordance with law. Today, despite the seemingly deferential language, virtually every significant action is challenged as arbitrary and capricious. Some scholars have suggested that the arbitrary and capricious standard was intended to codify rational basis review. More recently, courts have appeared to apply a more searching standard of hard look review. Either way, it's hard to escape the impression that application of the arbitrary and capricious standard has itself become arbitrary and capricious. And when court decisions appear to be exercises of will rather than judgment, the rule of law suffers. Meanwhile, elsewhere in Section 706, language directing courts to set aside agency action has become a prime vehicle for the proliferation of nationwide injunctions. Those expansive remedies have been criticized for encouraging aggressive forum shopping, circumventing the established procedures for class action litigation, and empowering individual district court judges to short-circuit the normal percolation of legal issues throughout the country. Whether or not the APA ever contemplated that state of affairs, these concerns warrant our careful consideration. In the end, reasonable minds may differ about how best to address these and other questions in administrative law. Today's summit will undoubtedly yield a variety of potential answers, but part of the virtue of today's summit is asking the questions in the first place. Every day in courts across the country, the Department of Justice represents the United States in high-stakes, fast-moving litigation that demands the nearly constant attention of both litigators and leadership. But we do recognize that in the long run, the issues we're taking the time to discuss today are no less important to the department's mission. Although we remain immersed in the legal controversies of the moment, I am proud to see the department taking a step back to reflect on these big questions. As you will hear from our next speaker, that is well in keeping with a long tradition at the Justice Department, dating back to its prominent role in the drafting of the original APA. At this time, it is my honor to introduce the Solicitor General of the United States, Noel Francisco. Noel has had an exemplary career in public service and private practice, one that has put him at the center of some of the most vital debates in administrative law today. Before joining the Department of Justice, he was a partner at the Washington, D.C. office of Jones Day, where he chaired the firm's government regulation practice and argued a number of important cases before the Supreme Court, including the landmark separation of powers case and LRB v. Noel Canning. From 2001 to 2003, he served in the White House counsel's office as associate counsel to President George W. Bush. And from 2003 to 2005, he served as a Deputy Assistant Attorney General in the Justice Department's Office of Legal Counsel. Earlier in his career, he clerked for Judge J. Michael Ludig on the U.S. Court of Appeals for the Fourth Circuit and for Justice Antonin Scalia on the U.S. Supreme Court. He was confirmed as the 48th Solicitor General of the United States in September of 2017 and has led that office with distinction for the past 2 years. Please join me in welcoming Solicitor General Noel Francisco.
Thanks very much, Claire, and thank you all for joining us this morning. I'm pleased to welcome many of you, and for many of you to welcome you back to the Department of Justice to kick off this important summit on modernizing the Administrative Procedure Act. We're fortunate to have a wide variety of leaders in administrative law spanning academia, private practice, and the government here to share ideas on how the APA can be improved. To set the stage for that discussion, I'd like to say a few words about how the APA came to be. It's fitting that the Department of Justice is hosting this summit because the department played a significant role in shaping the original APA. The process that culminated in the APA began in the 1930s when the federal government's effort to implement the New Deal led to dramatic growth in both the size and scope of the administrative state. This growth spurred calls from legislators, from advocacy organizations, and from regulated entities, amongst others, to impose some limits on the administrative state. By early 1939, several reform bills, some of them highly restrictive of federal agencies, had been introduced in Congress. Although it may seem hard to believe, the federal government was not wild about the idea of limiting its own power. Some things never really change. But given the political realities and perhaps the strength of the arguments on the merits, the Roosevelt administration sensed that reform was inevitable. So rather than fight the effort to rein in federal agencies, the administration instead sought to play an affirmative role in shaping the new law. To that end, President Roosevelt asked his Attorney General, future Supreme Court Justice Frank Murphy, to create a committee to study the issue and to propose legislation. In response, Attorney General Murphy created the Attorney General's Committee on Administrative Procedure, which included some brilliant legal minds, including then Solicitor General Robert Jackson, Professor Henry Hart of Harvard Law School, and future Secretary of State Dean Acheson. While the Attorney General's Committee worked to come up with its own proposed legislation, Congress was busy considering bills that had already been introduced. In December of 1940, Congress passed what was known as the Walter Logan Bill, a bill that was highly restrictive of federal agencies. As was expected, President Roosevelt swiftly vetoed that legislation, and Congress was unable to override that veto. The following month, January 1941, the Attorney General's Committee submitted its report, which spanned 474 pages and contained nearly 60 pages of conclusions. Although a few committee members issued dissenting statements on some issues, the committee generally agreed on most of the report's important recommendations. The Attorney General's report in turn sparked several bills in Congress, including one encompassing the majority conclusions and another the dissenting conclusions, and so the congressional debate over administrative reform continued. But later that year, any concern about administrative reform was eclipsed by a far greater crisis. On December 7th, 1941, 78 years ago tomorrow, our country was attacked at Pearl Harbor. In response, Congress and the President alike focused their energy on winning World War II. Only once the triumph of the Allied forces became certain did Congress fully turn its attention back to administrative reform. By that time, the Attorney General's Committee report had fully reshaped the legislative debate, thus vindicating the Justice Department's decision to play a leadership role in that reform debate in the first place. In fact, the bill that ultimately became the APA in 1946 contained many of the same reforms offered by the Attorney General's report. And after the bill's passage, the department continued to shape the debate by issuing the Attorney General's Manual on the Administrative Procedure Act, which has been highly influential in the judicial interpretation of the APA. Looking back from the distance of almost 75 years, I think it's clear that the APA has at least helped to hold administrative agencies to basic standards of rationality and procedural fairness. The administrative state is certainly more transparent and accountable than it would have been without the APA. Of course, the APA isn't perfect. Back when I was in private practice, a practice that included litigating lots of cases on behalf of clients challenging federal agency actions under the APA, I testified before the House Judiciary Committee about the need for APA reform. In my testimony, I highlighted 3 areas where I thought the balance had tilted too far in favor of judicial deference to agencies and away from judicial oversight. Specifically, I discussed the trend of agencies using informal rulemaking more often than formal rulemaking to reduce judicial oversight, the court's increasing deference to agency interpretations of law, and judicial underenforcement of statutes passed by Congress to promote agency transparency and accountability, like the Information Quality Act and the Regulatory Flexibility Act. As Solicitor General representing the federal government, I, of course, have a different vantage point from which to consider the APA. In fact, several of the most important cases that I've argued in the Supreme Court over the past few years have involved issues related to the APA, including challenges to the President's travel proclamation and the Department of Homeland Security's rescission of the DACA program. And I see an even larger number of APA decisions from the lower courts as part of my responsibility to authorize government appeals and emergency relief requests. Some of those cases have highlighted the danger of courts using the APA to second-guess the executive branch's legitimate exercises of statutory authority. But I continued to believe, as I testified back in 2011, that courts have an appropriate role to play in limiting agency excesses and enforcing the statutes that Congress has enacted. That was the balance that the department tried to strike in the brief that we filed last term in Kaiser against Wilkie, in which we argued that the court should constrain but not wholly eliminate the deference that courts grant to agencies' interpretations of their own regulations. The Supreme Court's opinion largely adopted our argument. In my view, that was a positive step towards restoring the right balance between the branches. Any progress made through litigation, however, is modest compared to what can be accomplished through legislative reform of the APA. And that is the primary topic of this summit. The first panel, entitled Lessons from the Life of Administrative Law, What Experience Teaches Us About How the APA Can Be Improved, will focus on the ways that administrative law and the administrative state have changed over the 7 decades since the APA's enactment and what those developments mean for legislative reform efforts. The second panel, APA Reform, What's on the Table, will focus on the numerous legislative proposals that have been made and in some cases passed by the House of Representatives to reform the APA, including by expanding hybrid and formal rulemaking, increasing the use of cost-benefit analysis, and broadening the scope and rigor of judicial review. The third panel will focus on the significant regulatory reforms undertaken by this administration over the past 3 years, such as limiting the practice of rulemaking by guidance and on the prospects of codifying those reforms in legislation. And finally, Deputy Attorney General Jeff Rosen, who brings to his job decades of experience in administrative law, both in and out of the government, will deliver a keynote address discussing the department's reform plans in greater depth. By convening this summit and by taking on the issue of APA reform more broadly, the Department of Justice is playing a critical leadership role in the legislative debate, just as it did with the original passage of the APA. Enacting meaningful legislation will not be easy today, just as it was not easy then. But history shows us that it's possible and that it is worth the effort. Modernizing and improving the APA is an important mission for the department and for the nation, and we will benefit greatly from the contributions that all of you bring to the table. So again, thank you for playing a part in this important effort, and I look forward to the discussion. Thanks very much, everyone.
Thank you, Noel, for those excellent remarks, which very nicely set the stage for the rest of our program today. I am now pleased to introduce Jen Mascot, who will moderate our first panel on how administrative law today deviates from the APA and what this suggests about how the APA might be improved. Jen serves as a Deputy Assistant Attorney General in the Office of Legal Counsel and is on leave from her position as an Assistant Professor of Law at George Mason's Antonin Scalia Law School. Jen's scholarship, which focuses on administrative law and the separation of powers, has appeared in the Stanford Law Review and George Mason Law Review, among other places, and has been cited by the Supreme Court. Jen has also served as a public member of the Administrative Conference of the United States, and earlier was a law clerk to Supreme Court Justice Clarence Thomas, and also to then Judge Brett Kavanaugh. She is a graduate of the George Washington University Law School and the University of Maryland. Jen, the panel's yours.
Thanks a lot, Dan, and thanks to all of you for being here today. We are delighted to start off our panel discussions this morning with an all-star lineup of administrative law scholars and practitioners. What I'm going to do is begin by introducing each of the panelists. They'll then give opening remarks. They'll take a brief opportunity to respond to what each other has said, and then we'll finish out the majority of the panel discussion with moderator-led Q&A and hope for some interactive conversation among us. We're going to start with Aaron Nielsen today. He serves as professor of law at Brigham Young University Law School. He teaches and writes in the areas of administrative law, civil procedure, federal courts, and antitrust. His publications have appeared in journals such as the Harvard Law Review, Chicago Law Review, Georgetown Law Review, among others. He chairs the Administrative and Management Committee of the Administrative Conference of the United States. He previously served as partner in D.C. Office of Kirkland & Ellis, served as law clerk to Justice Sam Alito, former Judge Brown of the D.C. Circuit, and Judge Jerry Smith at the Fifth Circuit. Then we'll hear from Helgi Walker, who's a partner in Gibson Dunn's D.C. office. She co-chairs the firm's Administrative Law and Regulatory Practice Group and is a member of the firm's Appellate and Constitutional Law Group. Her work focuses on appellate, regulatory, and complex litigation matters. She serves in a leadership role in many outside professional service organizations. Just some of her many roles include being a fellow of the American Academy of Appellate Lawyers and chair of the D.C. Circuit's Advisory Committee on Procedures. She previously served for 5 years as a public member on the Administrative Conference of the United States. She's a former law clerk to Justice Clarence Thomas, Judge Wilkinson of the Fourth Circuit, worked as associate counsel in the White House for 2 years from 2001 to 2003, and has worked in several capacities in the Federal Communications Commission. Then we have Nick Perillo, professor of law at Yale, where he teaches courses on administrative law and government bureaucracy. His publications have appeared in venues such as the Harvard Law Review, the Yale Law Journal, and have received awards from the ABA's Administrative Law Section, Law and Society Association, and the American Society for Legal History. In 2017, Nick conducted a comprehensive study of agency guidance documents for the Administrative Conference of the United States that he's going to touch on a bit today in his remarks. The study provided the basis for conference recommendations on agency policy statements and best practices and has led to a follow-on project on interpretative rules. He's testified before Congress, spoken before the Second Circuit Judicial Conference. He's a co-author of a casebook in administrative law and has received Yale Law School's annual teaching award. And then the final speaker will be Matt Weiner, who's the Vice Chairman and Executive Director of the Administrative Conference of the United States, an agency commonly known as ACUS. It studies the administrative process. It makes recommendations on how to improve it. So he's really our guru of all gurus of administrative law here today, overseeing a lot of the recommendations that ACUS has made over the past couple of years. Before serving in ACUS, he's also got a lot of experience in Congress, serving as general counsel to U.S. Senator Arlen Specter, counsel to the the House Committee on the Judiciary. He was a law firm partner at Deckert. Currently, he's an elected member of the American Law Institute and a fellow of the American Bar Foundation. So we have just a wealth of experience here this morning to talk to us about how current practice has changed and transformed over the years and the decades since enactment of the APA. And we'll begin with Aaron Nielsen from BYU.
All right, thank you. So that's exactly where I want to start off is how things have changed since the APA was enacted and the way that the law works. So here it is. It's hard to see this. I wasn't sure what the room would be. But when I teach administrative law, I tell my students there's 4 boxes of administrative law, and you always want to know which box you are in. The 4 boxes are formal rulemaking, informal rulemaking, formal adjudication, informal adjudication. And it matters a lot which box you are in because the APA's procedures are tied to the box. So you follow the statute and it tells you if you know your box, you know your procedures. And when the APA was enacted, the 4 boxes all did very different things. At the formal side, in formal rulemaking and formal adjudication, it was like a trial. The procedures were almost the same, but it was like a trial. There's burdens of proof, there's cross-examination, there's findings of fact, there's a closed record, and it was a rigorous trial-like procedural process. When you go to the informal side of things, informal rulemaking and informal adjudication, there were many fewer procedures. So if you look at 553 of the APA, those are the procedures for informal or notice and comment rulemaking, and they're very, very light. If you look at the procedures for informal adjudication, which is a huge number of things that agencies do, they're almost non-existent. There are some in 555, but there are almost no procedures. So it matters a lot which box you are in. So I think it'd be useful to kind of look at what has happened to these 4 boxes since the APA was enacted. So let's start with formal rulemaking, the Yeti of administrative law. That line comes from Justice Thomas a few years ago at the Supreme Court. Formal rulemaking is essentially dead. There's a few examples. I went back and I hunted and I found a few, so I've seen a few Yeti sightings, but it's essentially dead. So those procedures for that type of rulemaking, you just never really see used. What happened? Well, in 1973, in a case called Florida East Coast Railway, the Supreme Court very, very narrowly read the requirements for when formal rulemaking kicks in. So since then, if this organic statute doesn't use the magic words on the record, even if it requires a hearing, it doesn't require the formal procedures of formal rulemaking. So that box, one of the 4 quadrants of administrative law, is gone. Let's look at the next box, formal adjudication. Formal adjudication is not gone. It still very much exists, but it's also in retreat. The same formal procedures that exist for formal rulemaking since the APA's enactment, what's happened? Well, the present trend is to interpret the A554A, which requires formal adjudication, very narrowly. This is from the Hickman and Pierce Treatise. And a lot of that reasoning also flows from the Florida East Coast Railway limited approach of what a hearing requires. So the 2 formal boxes of our 4 quadrants are either gone or very much in retreat. Well, what about what's happened to our informal boxes? Well, since, especially as the formal has receded, more formality has been put on our informal boxes. So we say that it's just a general notice if you look at 553. Well, it's actually now not that. The notices of proposed rulemakings can be hundreds of pages long and very detailed. You look at 553, that does not appear to be how 553 envisioned it. And further down the line, you have material comments doctrine, which says that if agency receives a comment that's material, they have to respond to that. You look at 553, it's unclear if that was there. The logical outgrowth doctrine, which says that the proposed rule and the final rule have to be a logical outgrowth connection between them. I think that's maybe a fair reading of the APA that you get there, combine 553 with 706, but it's unclear, but nonetheless very much is part of the process. Hard look review for arbitrary and capricious, the Portland Cement doctrine, agencies to turn over their data, and so on down the line. So the simple process of 553 now looks a little bit more like the formal process of formal rulemaking. What happened here, Portland Cement, then Judge Kavanaugh was unclear about whether that's tied to the record, but I just urge you to look at the text of 553 and then compare it to how things actually work today. Finally, informal adjudication has also had additional procedures put on it, at least de facto. If you don't want to end up in court, there's a very good chance that you're going to contemporaneously explain what you have done, because otherwise you might get a court order telling you to do so. So you act in the shadow of the law, and nonetheless you say it, and thus you regularize the procedure for the informal adjudication quadrant. So here it is. This is the change since we had in 1946. I just want to have kind of two concluding thoughts. One is it shows that the APA is time for an update. It's showing its age. The way that we do things to now does not very well map on to how it was enacted then. And the last thought, for those of us who are proceduralist-minded, kind of like formal procedures, you say, well, what's happened to those two boxes of administrative law, either gone or very much in retreat?
Thank you, Aaron, very much. We look forward to hearing more in the Q&A. Helgi.
So I think on the panel this morning, I'm the voice of the private sector. I'm in private practice. I represent regulated entities subject to the many reams of regulations that govern their business and their operations more so than statutory law. And that's, of course, as everybody in this room knows, just a function of the tremendous growth of the administrative state itself. So I feel a special obligation here to speak from the point of the view of the regulated entities. And let me tell you, it's cold out here in the wilderness. We live every day in a blizzard of regulatory documents, FAQs, letter rulings, suggestions from regulators, winks and nods, when it's up to us as lawyers to tell our clients what the relevant rule of law is. So finding your way through that blizzard, that snowstorm, to the warm, cozy place where you know what the rule of law is extremely challenging in this modern age of administrative law. So my view is going to be the view from the trenches, if you will. So let's start with the concept of administrative lawmaking, and let's assume that that's a legitimate concept, non-delegation doctrine, Humphrey's executor, and all that good stuff notwithstanding. There are some very beneficial parts of the APA and the notice and comment procedures that Congress enacted back in the World War II era. Regulated parties can bring their knowledge and their expertise to the regulators and try to inform the best outcome and the way to properly shape a rule. Congress can at least know that agencies are out there rulemaking under the statutes that they created and conferred the authority, hopefully, to the agencies with. But most importantly, the people can see in advance the new laws, the new rules that are coming down the pike and conform their conduct to those potential standards in time that they can be compliant before the new rules take effect. But unfortunately, what I've described, and I think it's not with any bad intention on the part of the many great people who work at federal agencies, is more theory than reality. What we see more and more, as I suggested with my blizzard analogy, is documents that stream out of agencies every day that do impose binding legal standards, substantive norms, yet are not adopted through these beneficial notice and comment procedures. What we see more and more is what I call backdoor rulemaking, and that's unfortunate because it is lawmaking without the transparency and the public input that's required by the APA. I'll take one example that we're seeing now at the SEC. 12b-1 fees are fees that mutual funds pay lawfully to investment advisors under the SEC's own rules. Starting in 2010, the SEC decided it wanted to try to update these rules and essentially heavily regulate 12b-1 fees, or maybe even outlaw them altogether. That rulemaking failed. What happened after the rulemaking failed? The Enforcement Bureau started issuing a series of documents. One called the Shared Class Initiative, where, and I'm not making this up, the Enforcement Bureau encouraged investment advisors to self-report, to confess that they'd been violating the 12b-1 fee rule all along, which again allows these fees. And the Enforcement Bureau actually said that parties that didn't come forward and turn themselves in would suffer heavier penalties later on. Then the Bureau started issuing FAQs, establishing new standards. Long story short, over 100 investment advisors have turned themselves in and paid back $100 million in 12b1 fees when that conduct is entirely legal under the SEC's extant regulations. That's the sort of troubling regulation by pressure campaign instead of by compliance with the APA that we're seeing out there in the real world. So I have 3 suggestions in my remaining time here about what to do as a practical matter. One idea, and this is perhaps too idealistic, but one great idea would be for Congress to actually do its job. Congress could make the hard policy calls to decide whether and how to regulate in a particular area. But Congress, as we know, under this regime that has grown up over the last 75 years, tends to kick the hard policy decisions to the agencies where the politics are then and the policy are then fought out. But if Congress really did its job and at least established something more than a bare intelligible principle and made those tough policy calls, we'd have more democratic accountability in the first place, and we wouldn't be here talking about how to rein in independent agencies at all. But assuming that it's too hopeful that one can think that Congress would actually do the hard decision-making, what would I do now? I might make the Congressional Review Act subject to judicial review. Section 805, of course, says there's no private right of action. We might see better compliance with the CRA's requirements that guidance documents actually go to Congress for review and possible overturning. Second, I might adjust the understanding of final agency action. Since the act was adopted, we've seen a very formalistic understanding of what is final agency action under Bennett versus Speer, but for those of us who are out here, as I say, in the trenches, it really ought to be, I think, expanded to understand the realistic effects of agency pressure to comply with substantive norms and to allow for greater judicial review. And third, while I loved the administration's new executive orders, including 1389 on guidance documents, I would suggest extending that executive order to independent agencies, which is where so much of the problematic conduct actually occurs. So those are my suggestions for reform. And thanks, Jen.
Thank you, Helgi. We look forward to exploring those more in the Q&A. We'll now hear from Nick.
Thanks very much, Jen. So following directly from Helgi Walker's remarks, the APA dispenses with the mandate for public participation when an agency issues guidance, because guidance officially is non-binding. But as Helgi explained, in real life, regulated parties facing guidance often feel that they have no choice but to follow it. And I want to talk about why things have turned out that way, because I think the causes are factors that any reform of the APA are going to have to grapple with, central things that any reform of the APA would have to grapple with, and there's no perfect way to do it. And here I'll draw from the study of guidance that I conducted for the administrative conference, for which I interviewed 135 individuals across industry, NGOs, and the agencies themselves. So sometimes agency officials really do intend to change policy in a way that binds the public, and they adopt the format of guidance just because they want to avoid the APA's participatory requirements, and that's bad. But I think the most important thing for us to realize is that most of the pressure that regulated parties feel to follow guidance can be explained just as easily, usually more easily, by causes other than deliberate official circumvention of the APA. Modern regulatory statutes often, though not always, create such strong incentives for regulated parties to follow the agency's thinking that whenever the agency expresses its views, regulated parties are likely to change their behavior accordingly, regardless of whether the officials seek to coerce anyone. For example, this occurs if the regulatory statute requires firms to obtain the affirmative permission of the agency merely to do their business. For example, the Food and Drug Act's requirement for pre-market approval. A pre-approval statutory scheme, along with certain other types of statutory structures that I identify in the study that cover most, though not all, or many, though not all, regulated industries, are what impose the pressure to follow whatever views the agency may express. Now, you may hear all that and say, well, okay, then the agency should realize that the views it expresses are inevitably freighted with all this implicit power, given the statutory background from the enabling legislation. And if the agency expresses views merely through guidance, then the agency should mitigate this inevitable implicit power that its views carry by treating its views as merely provisional. That is, the agency in any individual matter should be open to the regulated party's arguments for doing things differently from the guidance. In other words, the agency should be flexible. Now, all of that is right in principle. The problem is that another word for flexibility is inconsistency. And agencies face very strong pressures, understandable pressures, to be consistent, which does a great deal to explain why they often fail to be flexible. If an agency behaves flexibly and makes a departure from guidance at the behest of one regulated firm, then the competitors of that firm will justly complain that the agency is depriving them of a level playing field. Often, what firms mainly want from a regulator is predictability and even-handedness, and flexibility in guidance undermines both of those things. Alternatively, a firm that sees its competitor win a special dispensation from the agency may itself go to the agency and say, our firm wants that exception too, and to avoid getting overloaded by many such demands, the agency may just say no to everybody. In an ideal world, the agency would escape the trade-off between flexibility and consistency by being flexible but in a principled way. That is, if the agency accepts a firm's argument for proceeding differently than guidance suggests, the agency would give a public explanation for that departure, and that explanation would then be available to all similarly situated firms going forward. That approach keeps the playing field level, and it maintains predictability going forward. There's just one problem. Formulating and adopting and publishing reasons is expensive. It takes data gathering, staff time, and sign-off by busy high-level officials. Finishing up, given scarce resources, it's rare that agencies can afford to be fully reasoned and principled when they make departures from guidance, and if that's the case, then the agency using guidance either needs to be flexible in an unprincipled, unpredictable way, or not be flexible at all, which undermines the APA's participation mandate. So any reform of the APA is going to have to grapple with this trade-off. The trade-off can be made in different ways to give different weight to the competing values, but it cannot be entirely avoided, at least not without more agency resources or more efficient use of those resources.
Thank you, Nick, very much. Now we'll hear from Matt Weiner.
Thank you very much. Thank you, Jen. Thank you, Deputy Attorney General Rosen, for organizing this symposium or summit and inviting me. ACUS actually traces its origins back to the Justice Department, so I'm very, very happy to be here on behalf of ACUS. Excuse my voice, I'm getting over a cold. My assigned topic today is administrative adjudication. It's probably the easiest topic on the panel. For the answer I give to the title question of the panel, how can the APA be improved, at least as far as adjudication is concerned, is that it can't be, or perhaps it shouldn't be. And I doubt anyone on this panel or on any of the other panels will give a different answer. Adjudication certainly occupied a central position in the drafting of the APA. It's largely absent from major legislative reform initiatives introduced over the last several Congresses, although it's been the subject of some excellent scholarship of late. Adjudication is not any less important today than it once was. It is a central feature of the administrative state. Nobody knows exactly how many adjudications there are on an annual basis. The number, some people would put the number in the tens of millions. It certainly, the number of adjudications certainly dwarfs the number of federal cases, federal court cases each year. What does the APA have to say about adjudication? It provides for trial-like proceedings, formal hearings as they're sometimes called, in adjudications, quote, required by statute to be determined on the record after an opportunity for an agency hearing. That's 5 U.S.C. 554, which Aaron had put on the screen. These are so-called formal adjudications. I will just call them APA adjudications. For short, APA adjudications require, as I think most people in this room know, some basic procedures. Among them that the agency's decision be based on an exclusive record and not extra record evidence and materials. And most importantly, perhaps, the hearings must be conducted with 2 exceptions in the APA that I won't mention before an administrative law judge. And an ALJ is an agency employee, in short, whose compensation the agency doesn't control and who, under statute, may only be removed by the Merit Systems Protection Board upon a showing of cause. Now, the cause provision in Title V is the subject of some legal controversy, and I'll leave that alone for now. The overwhelming majority of adjudications, maybe over 90%, I think Justice Scalia once put it at that number, are what's traditionally called, perhaps misleadingly, informal adjudications. These are adjudications not subject to the formal hearing proceedings of the APA, and they, like all adjudications, are really only subject to one APA provision, putting aside the judicial review provisions of the APA, and that's Section 555, which requires, among other things, that parties be given the right to counsel. Most adjudications, in short, are not regulated by the APA in any meaningful sense. They can be said to lie outside the APA. In the words of the title of a recent source book that ACUS has published, entitled Administrative Adjudication Outside the APA. Now, the Administrative Conference has spent a lot of time working and trying to improve a subset of non-APA adjudications that might be called trial-like non-APA adjudications. These are adjudications that in many sense are very formal, even though they're not governed by the provisions of the APA, and some are indeed much more formal than any number of APA adjudications. How many of these trial-like non-APA adjudications are there? Hard to count. One way of trying to count is to look at the number of adjudicators. So if we look at the number of ALJs presiding over APA adjudications, the number is about 1,900. If you exclude the Social Security Administration, you're probably only talking about 200 ALJs presiding over APA adjudications. That would suggest that there are not a lot of APA adjudications. There are probably somewhere between 5,000 to 10,000 non-ALJ adjudicators presiding over trial-like non-APA adjudication. The governing law in non-APA adjudications, not the APA, Section 555 aside, statutes. Sometimes Congress has set up elaborate adjudication systems. The Patent Office would be an example. The immigration court system would be an example. The immigration system would be an example. But most practices in trial-like non-APA adjudications are governed by agency practices, agency rules of procedure. I have not heard in the current debates over the APA anyone who seriously has contended that the APA's adjudication provisions need to be amended. The real question, perhaps, is whether more adjudications should be brought in under the coverage of the APA. I don't see any reform initiatives. I have not seen any reform initiatives in Congress to that end. And if additional adjudications were to be brought under the umbrella of the APA, it would almost certainly require congressional action, given what Aaron mentioned is the court's restrictive interpretation of the gateway provision to APA adjudication. Perhaps the more important question for Congress, and this is a controversial question, is whether Congress should assign certain adjudications now before agencies to Article 1 courts, Article 3 courts, excuse me, or newly established Article 1 courts. That's a big topic for another day. We do see a bill here and there that would move certain adjudications to Article 3 courts. They've come up in the context of the SEC and the NLRB, but there have been no ambitious reform initiatives afoot. My last point here is that my own view is that Congress should attend to problems with adjudication programs, agency by agency, program by program, not across the board. It might, in some cases, prescribe key structural features of adjudication systems, but not detailed procedures that would deprive agencies of needed flexibilities to deploy their expertise. Those should be left to agencies, just as Congress has left procedural rulemaking in the federal courts to in the hands of the Judicial Conference and the Supreme Court under the Rules Enabling Act.
Thank you, Matt.
Thank
very
you.
Much. Appreciate everybody's remarks. Before we move to Q&A, do any of the panelists want to comment on each other's discussions? We've heard from Aaron on rulemaking, and Helgi and Nick both addressed guidance and some of the administration's recent executive orders. Matt, with adjudication, do any of you have comments or responses to the way each of you have characterized the current state of the law?
Sure. I mean, so I just want to take a minute. I thought that Helgi's remarks were very well taken. And there's a problem, though. There's an additional problem with backdoor rulemaking, which I think was the term that she used. In other words, rulemaking where you're trying to create policy, but you're not going through the APA procedures to do that. And that is, it inherently has a very short shelf life. And as we see more and more from administration to administration, you see zigzagging, whipsawing policy changes. Well, that's actually really, really hard for the regulated community because you have to make long-term decisions if you're going to build a plant, for instance. What is the nature of the regulation going to be on this plant? And if you can't know what the law is going to be, next year, much less 10 years from now, it's really, really hard to make informed decisions. That's a deadweight loss on society. It would be better if Congress would enact laws because then they have a greater stickiness to it. But if you live in a world of the pen, you die by the pen, and I think that's not an ideal situation for anybody.
Helgi, did you want to respond to?
Yeah, I'm so thrilled a law professor thought my comments were well taken. I feel like I got an A+ this morning. I think that's all the more reason, though, why there ought to be notice and comment rulemaking, because it's harder to undo a rule that's been adopted by notice and comment than it is to undo a guidance document. As I was listening to Professor Perillo, one remark I wanted to make in response is that I think the trade-off between flexibility and consistency is a little bit of a false tension, or at least I think I know the way out of the box. And the way out of the box is with a rational enforcement policy. It is absolutely fine for regulated companies that want to voluntarily conform their conduct to a guideline to do that. That's fine. The problem is when the agencies enforce these guidelines retroactively and punish the companies that don't voluntarily comply their conduct with the guidelines. So if an agency had an enforcement policy that said, we're going to go after people who violate the clear text of our actual regulations, we're going to concentrate our enforcement resources there, we are not going to pursue people who are out of step, perhaps even with the industry, under a guideline document or an FAQ or this share class initiative where the Enforcement Bureau invited people at the SEC to turn themselves in for complying with the actual regulations. That would solve the problem. It's really the retroactive enforcement with punitive measures that is causing the pain in the regulated sector.
So if the stakes perhaps were lower on what was being done with guidance documents, then some of the trade-off perhaps would be less significant. Nick, did you have a thought on
Sure, sure. I mean, I guess I'd say that, in talking with people who've been on both sides of the enforcement process, I mean, to me at least, that was a context in which they emphasized the need for consistency, even at the cost of flexibility, in part because the willingness of regulated entities to self-report, the willingness of regulated entities to settle relatively rapidly in a manner that, husbands agency resources and that kind of thing, depends on a sense on the part of the regulated parties that their competitors will be treated the same way. And so that's part of what induces cooperation, induces self-reporting and settlement and that kind of thing. It makes an enforcement program more feasible. I also, if I may, just wanted to respond to a point by Aaron. Aaron makes this important point that additional process associated with policymaking can be a feature and not a bug because it makes things more sticky, it promotes reliance, it promotes stability in the law. And I wonder, I mean, if we're talking about reforming the APA and essentially writing on a blank slate, would it be better for additional process to come in the form of more frequent use of formal rulemaking, which is a kind of lawyerly adversary process? Or would it be better to mandate other forms of increased deliberation, such as mandating more advisory committee processes or more National Academy of Sciences studies or things like that? What are the options as between a more lawyerly adversary process and a more kind of interdisciplinary scientific process if we're going to spend more resources on process because we think it's important?
Thank you, Nick. I want to give Aaron a chance to respond to that, but first, Matt, did you have general thoughts on?
My only general thought is that I'd like to just associate myself with Helgi Walker's comment that Congress could in fact do its job. Now, there is too much delegation. I don't think there's more delegation now than there was, say, 4 decades ago. Perhaps there's less. But Congress assuredly does abdicate its legislative responsibility in key respects. I'm a little skeptical of forcing mechanisms of the sort, say, that Judge Naomi Rao has put out in a very good article a number of years ago, such as, sort of a revival of the non-delegation doctrine. But there is indeed a problem with Congress not adequately legislating and not attending to problems in the administrative state. And personally, I'm not someone who traffics in optimism. I don't see any realistic possibility. I hate to be negative, but I don't see any realistic possibility that Congress is going to do anything in the near to midterm, given the political gridlock and dysfunction in our politics generally.
Thank you all. Well, I mean, and so some of the action actually that has taken place recently, even though there has not been legislative reform, of course, is 2 recent executive orders from President Trump's administration on guidance. And so I want to make sure that we have time to talk about those, and in particular ask Nick and Helgi if they believe that those executive orders will change some of the practices that have been going on with agency guidance. But before moving off of Nick and Aaron's exchange about formal rulemaking, Nick, you seem to suggest or question, is formal rulemaking with trial-like procedures really the type of procedure that we'd want to see added into the rulemaking space if Congress were to engage in reform? And Aaron, I was curious as to your thoughts about whether there are unique benefits or things that happen with that trial-like process that maybe we're not necessarily getting through notice and comment, either under the terms of the APA itself or under this kind of heightened hybrid rulemaking, which you acknowledge in formal rulemaking now actually has more procedural constraints that courts are imposing on agencies than in the past. Is that an adequate compromise between the 2 forms of rulemaking as set out by the APA, or is there something unique that happens with the formal rulemaking procedures?
Sure. So this goes a little bit the last thought that I was trying to make in my prepared remarks, which is, for those of us who are proceduralists, what to make of today. And I'll say this: it's hard to be an empiricist when we have no data. So we have formal rulemaking, which is the EDI. We don't have a lot to look at. So you can look at the ones that have been happened in recent years, but there just isn't a lot of data. So I think experimentation would actually be quite valuable. But on the broader point, so here's for what it is worth. When I was a very new law professor, I heard a remark that nobody for 30 years had ever defended formal rulemaking. And being the kind of person that I am, I said, oh, let's go back and read that article to see what they said 30 years ago. So I went back and I spent a good chunk of a summer looking in the 1970s materials about the debates to figure out what was going on at the time. And there was a lot of very smart people in the 70s who recognized some of the value of a formal rulemaking-like process, in particular cross-examination. So, Matt is here from the Administrative Conference. And the Administrative Conference in the 1970s did not think formal rulemaking should be required, but recognized in a couple of recommendations the value of it, especially for highly technical sort of matters. I think that I think Nick's point is very well taken that, yeah, maybe we'd want science advisory committees or something like that, but there's a lot of value in having a good cross-examination closed record where you have the expert on the stand and you say, this is your analysis, have you thought about this, have you thought about this, have you thought about this, and go down a checklist, and you have a nice transcript where you can look at and say, this is the issue, that instead of having 100,000 pages in the record, you have a nice transcript page that says, this is the key issue, have they thought about it? I think it makes judicial review easier, I think it makes, the issues are more fleshed out. Those are the values that I have. But again, it's hard to be an empiricist without data. So I'm not sure. Now, your other part of the question, which is, well, what about we just ramp up the procedures on the informal side? Well, I think that there's some problems with that as well. I like a lot of the procedures that we've kind of developed through a common law way. I think Portland cement makes a lot of sense. Material comments make a ton of sense, for instance. But we don't have that particular benefit of, here's the expert, instead of spending 3 years in litigation, how about we just get this figured out now? You have your expert, we've got our people, we're prepared, let's get it on a transcript, let's figure it out. And none of the embellishments on informal rulemaking do that, and I think that there's value in something like that.
Thank you, Aaron. And that's an interesting point about experimentation, maybe trying some formal rulemaking and seeing how it works. One of the points from your scholarship that I found interesting in going back through it too is that we sort of have an idea maybe that formal rulemaking is going to be so restrictive that nothing will get done and things will grind to a halt. But you in your paper go back to, I think, to some of the examples that did exist and say we almost have a wrong memory in our mind that sometimes those trials were not perhaps as lengthy as even some informal rulemaking that we have today. Moving to Helgi and Nick's discussion on agency guidance documents, I'm curious if both of you have thoughts on how in particular, the recent executive orders 13891 on trying to improve agency guidance, making sure agencies post documents in a public way, and then 13892 on what kinds of documents can be used in enforcement. I wonder, Helgi, how you think that might impact some of the enforcement costs that you're talking about coming from guidance documents. Will these efforts perhaps lower the stakes a little bit by instructing agencies not to rely so heavily on guidance documents?
I mean, I think us, again, out here in the private sector, we thought the executive orders were a huge breath of fresh air and a wonderful part of the administration's effort to grapple with the administrative state and put some practical constraints on it. As I said in my remarks, I think what I would have loved to have seen on the guidance order is to have independent agencies expressly covered, because that's where the bulk of this rulemaking by guidance is coming from and where the regulation by enforcement is coming from. But I don't want to lose sight of the fact that they were tremendous strides forward in improving this area, and I think the administration is to be much commended for them.
And before moving to Nick, one of the other ideas you mentioned is tightening up or broadening perhaps the definition of final agency action. I was curious if you had thoughts about what all you thought perhaps courts needed to more clearly bring in under the guise of final agency action so it could be more easily reviewed. Helgi, that was to
me.
you.
Oh, okay.
Sorry.
I was going to give Nick a chance. Final agency action is a very mushy term, and Bennett versus Speer didn't really define it in a overly helpful way. The Supreme Court said it has to be the consummation of the agency's decision-making and legal consequences have to flow from it. Well, that's very broad, and that encompasses a lot of the guidance-type documents that we've been discussing this morning. If I could just come back to a very practical point of view, none of this really matters unless we have judges that are willing to look skeptically at what an agency says about whether its guidance document is binding or not, and who kind of understand how the real world works and are willing to say that this thing that's labeled non-binding is for all practical purposes binding, and the agency is treating it that way. And to use a Justice Thomas line, which Jen Mascot will hopefully get and will make her laugh, we need judges who know the deal, right? Like who know how this works. And I think kind of the high watermark for that kind of an approach for me is Judge Silberman's approach in Lutheran Church in 1998, where he said, quote, "No rational firm welcomes a government audit." And on the basis of that kind of understanding, that there's huge pressure for regulated entities to just go ahead and comply because there is a threat of an enforcement action, which with even non-binding guidance, I mean, that's the kind of skeptical judicial review that I think at the end of the day makes the APA meaningful, is judges who are willing to recognize what Judge Silberman called de facto law. There's lots of de facto laws out there, and marrying that notion of de facto laws with final agency action is important to give the judicial review provisions of the APA meaningful effect.
Thank you, Helgi. And so then turning to Nick, and Nick's study for ACUS is quite comprehensive, and if folks have not had a chance to take a look at it, I would encourage you to look at it, because as he mentioned, he did interview many folks looking at this from many different sides, and so just in terms of learning what the current practice is, there's a wealth of information there. And one of the points that you made in your remarks and also in the report is these institutional factors that are almost leading to hydraulic pressure of agencies and regulated parties relying on guidance documents. And so I'm curious as to how you think, if you think that the recent executive orders will bring any change there, and perhaps by putting some more obligations on agencies when they use guidance documents, will that reduce some of the pressure on those sources of standards?
Well, sure. I mean, I'll speak particularly to Executive Order 13891 from October, which I think very consequentially says that when agencies issue a significant guidance document, a category that's quite broadly defined, they ought to take pre-adoption, or they're required to take pre-adoption notice and comment, and they have to promulgate their own binding procedural regulations that mandate such pre-adoption notice and comment, and that furthermore, this sort of notice and comment light for guidance documents should include a public response from the agency to major concerns that are raised in the comments. So, I mean, this has obvious benefits in the sense that, it can increase the quality of policymaking in all sorts of ways to hear more comprehensively, from the regulated industry and other stakeholders before policy, even officially non-binding policy, is promulgated. The fear that's been raised is that this will raise the process cost of issuing guidance so much that it'll become like legislative rulemaking, and a lot less guidance will be issued, and there will therefore be less transparency in regulation. I am not that worried about that because we do have agencies that are quite experienced in doing a notice and comment process pre-adoption for guidance. The FDA has done it pretty comprehensively for 20 years. The EPA has done it ad hoc, but it's been pretty frequent. Other agencies also have experience with it. And what people who have experience with that process will tell you is that it has not caused guidance issuance to become like legislative rulemaking. It has not ossified things nearly as much as legislative rulemaking has been, quote, ossified, to use the pejorative term. The reason, they say, is that even though you're taking comment from the public and learning from the public and enriching the quality of the policy, you're not looking ahead to judicial review, and you're not therefore obligated to build the enormous record that is needed to bulletproof the policy before an unpredictable panel of 3 generalist judges. And so, I think, given that the executive order obviously doesn't affect the judicial reviewability of guidance, this increase in process that's kind of internal to the agency is not likely to be very costly. It might run into one other pitfall, though, which is this, and this has happened sometimes at the FDA and elsewhere. It may be that the agency puts out the guidance in draft seeking comment, but the agency has limited resources. It doesn't have time to read and process all the comments and write the response because it's being asked to provide draft guidance about other things and is being asked to do a million other things. And therefore, the agency just leaves the guidance in draft more or less forever. But it's draft guidance that expresses what the agency almost certainly wants. So, wink, wink, nudge, nudge, the regulated parties get it and they start to do what's in the draft guidance, even though it's only a draft. There's a guidance document at the EPA that was in draft for 27 years. And everyone knew that you needed to follow this draft guidance if you wanted to get, the permit that it governed or what have you. So, again, given limited resources, it might be that the procedural rules under the executive order will run into that pitfall that guidance just stays in draft for a long time. There are ways to mitigate that, but it is something to look out for.
Thanks, Nick. Helgi,
Can I just point out something that's especially unfair about what Nick just described, again, from the status of the regulated entities? Maybe there's a group of companies that know what the FDA really wants because they know about this draft guidance and they know that that's what you're supposed to do. But imagine a smaller company. Imagine a business person out in Iowa who are not part of this special club or haven't hired the expensive lawyers that know the person at the FDA who knows where the draft 27-year-old guidance document is located and can show it to them. And I think what we're supposed to be thinking about under the APA is the public and the people that don't have access to that kind of special inside information to know what the law is.
Yeah, and I would imagine some of those concerns are probably what was motivating the instruction in the executive order to also make sure that things are published. So you all are talking about the complexities of draft guidance, but I think if it sounds like it's got to be a multi-pronged approach, that the guidance documents be public and then also there not be enforcement actions taken on the basis of any of these standards until people know. And Matt, we are nearing the end of our panel. We have a few more minutes. I wanted to make sure we touch on some of what you had to say about adjudication, and you suggested that and pointed out that a lot of the reform efforts have been focused more on guidance and rulemaking than adjudication. But I'm curious, with your expertise working with a lot of agency adjudicators, do you think that current practice has struck the balance that was struck historically or that the APA intended between following the formal APA adjudication procedures and informal, and in particular I'm thinking of the separation of functions that the APA tries to put into place between those who are investigating potential violations of rules and those who are making them the decision, adjudicating folks' rights under those standards. In your view, does it seem like under current practice that as many modes of adjudication are subject to those constraints as would be ideal or was intended?
Sure. Before I answer your question, let me just take some credit for the executive orders on behalf of the administrative conference. The executive orders are actually in accord with several important recommendations of the administrative conference, and I have it on pretty good word that at least in some respects the executive orders were informed by ACUS recommendations that in turn, at least one of which was based on Nick Perillo's excellent report. In answer to your question, ACUS has done an extraordinary amount of research into administrative adjudication since its refounding in 2010, thanks largely to the efforts of Paul Verkuyl, the first or the last chairman of ACUS. And most of the ACUS research has focused on what I've called non-APA-like trial-like non-APA adjudications. What we found, and this is a large generalization, and it's subject to many exceptions, as any generalization is. But what we found is that most of these adjudications, these non-APA adjudications, are conducted in conformity with a lot of the key principles that are set forth in the APA, including the exclusive record principle. Probably the main difference in many respects is that whereas APA adjudications are presided over by an ALJ. Non-APA adjudications are presided over by non-ALJ adjudicators, whether they're called administrative judges or immigration judges or patent judges or what have you. There are some who have suggested that these adjudicators don't enjoy sufficient decisional independence and are too closely aligned with the agencies. They are, after all, civil servants who enjoy the same and generally no more protections than other civil servants. I understand that concerns have been raised about the independence of such adjudicators vis-a-vis their agencies. I'm not convinced that any problem has been demonstrated writ large across agencies, but this perhaps is a subject where more empirical investigation is needed.
Thank you. So we have a couple of minutes before panel one comes to conclusion, and so I wondered if any of you have closing remarks in response to each other, or just as you've listened to each other talk, as to how you think things should be done moving forward, or just key takeaways of where we are now, 70 years after AP's enactment. Yeah.
Just
Aaron.
really, really briefly, I would like to second Helgi's thoughts about retroactivity in the law. I think that is a lot of the misuse of guidance and things of that sort comes from the ability an agency has to get you for things you didn't know that what you were doing was wrong. And I don't think that's consistent with basic American values. And I think that's something that I like the executive orders for trying to address. But as we go forward with reform, I think retroactivity should be very much part of that discussion.
Any other closing thoughts, Nick? Did you?
I'm sympathetic to Helgi Walker's argument that the court should take a more functional approach to finality and thereby open up the courthouse doors more to judicial review of guidance, but I'd qualify that by invoking a point made long ago by Peter Strauss, which is that in an ideal world, you'd open up judicial review of guidance as to consistency with the enabling legislation, which is often what regulated parties really care about and where they have the best claims. And also, it wouldn't be that costly to do that kind of review. And also, in an ideal world, you would not fully open up judicial review of guidance documents to arbitrary or capricious review, because with that type of review, you get the incentive to build up enormous records that's going to end up chilling the provision of guidance in the first place and render regulation less transparent to begin with. It might be difficult for the courts to construe finality to mean one thing in one context and something else in another context, which is why this would be much better taken care of by Congress.
So one theme it seems like we've had in our panel is that in many ways procedures have changed over the years, and the stakes are incredibly high because of the increased regulatory activity over the decades, as many folks have mentioned this morning, and just increased stakes and for regulated parties. And we appreciate you all talking about the text of the APA, the various procedures, the complexities of where we are now, and look forward to hearing more from the future panelists this morning on what's been happening as far as legislative reform proposals and some ideas for the future, and just really want to thank all of you for setting the stage for that later discussion. Thank you very much.